Good morning. Today we're going to talk about an overview of Title VI compliance and enforcement. We're going to talk about why Title VI is so important, what Title VI states exactly, and how to make sure that your organization is doing what it needs to do to be in compliance. And that includes how to evaluate your organization's Title VI compliance and how to enforce that compliance, what you should be doing within your organization to make sure that you are following Title VI. So, what is Title VI exactly? It's a federal law that prevents people, organizations who are receiving any type of federal funding or assistance from discriminating against a client because of race, color, or national origin. And this law also requires that agencies providing services to someone who may not be able to speak English provide language services. And in this case, in the law, language relates to that national origin provision. So Title VI is really about non-discrimination on the basis of race, color, or national origin. So here is the text of the law. This is exactly how the law reads. No person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to any discrimination under any program or activity receiving federal financial assistance. So again, it's very simple. We're really hitting on race, color, and national origin in this particular anti-discrimination law. And this law covers a lot of organizations, particularly nonprofits, governmental organizations, and others. And we'll talk a little bit about that. So here are some examples of programs that are usually covered. Elementary, middle schools, high schools, and colleges and universities that are publicly funded. Things like social services, Department of Children's Services, public transportation like busing systems, parks and recreation, law enforcement, firefighters, housing and community development, so things like HUD programs, and also, of course, victim services programs that receive federal funding. So many of you are watching or listening to this because your organization receives some form of federal funding and is therefore covered under the Title VI Non-Discrimination Act. What is not covered? Employment is not typically covered with Title VI. There are exceptions. If employment practices result in discrimination against clients, then this is an issue. It's a Title VI issue. Or if your federal funding is specifically earmarked to provide employment, then employment becomes a Title VI issue. And so for many 501c3s, and particularly victim services agency, employment is covered within the umbrella of Title VI, non-discrimination. And what else is not covered? Discrimination based on age, sex, gender identity, disability. None of these things are covered under Title VI. Now that doesn't mean that they are not covered under other laws and provisions that your organization has to be beholden to. That doesn't mean that your organization doesn't have non-discrimination guidelines around those other protected classes, but Title VI does not cover it. Now, as a victim service agency, if you receive money from OVW, DOJ funding, which includes things like VAWA, VOCA, FIPSA, all of those things include non-discrimination clauses that do cover things like gender identity, disability, age, sexual identity, all of those types of things. But our focus today is on Title VI, which again really focuses on purely race, color, and national origin. So when we talk about receiving federal financial assistance, there are a few different types of things that we're talking about. Primarily for our purposes, as nonprofits, as victim service agencies, we're talking about grant funding. If you're receiving any type of federal grant funding, if you receive any type of funding from the coalition, if you receive any type of funding from OCJP or from the state, if you receive any type of OVW funding, VOCA, FIPSA, all of those things are federal financial assistance and in the form of grants. Other things are, stipends for training, equipment, space, facility, any type of federal assistance that can be codified. So if your agency or your entity receives even $1 of federal money, then Title VI applies to you. The purpose of Title VI is multifold. So one of the purposes is to make sure that minority populations know about programs that are accessible to them. So it's to make sure that everyone is able to access programs that are funded by the federal government. So everyone knows about HUD programs. Everyone knows about public parks and recreation. Everyone knows about public transportation in your community if it's available. And again, everyone should be informed of and should know about your organization or the victim service agencies that receive federal funding. So we're making sure that minority populations, immigrant populations, non-English speaking populations, different racial and ethnic groups are aware of the resources that are available to them. It prohibits locating facilities in any way that would limit or impede access to a federally funded service or benefit. So thinking about where your facility is located, if it's accessible, if it's, for instance, if you're lucky enough to be in a city or town that has a lot of, that has a lot of public transportation infrastructure, is your facility located along a bus route so that if individuals have to use public transportation, they can access your organization easily? Does your organization take into account transportation needs or how people are getting to your facility? And making sure that you're not placing an undue burden on certain communities. It encourages the participation of minorities as members of planning committees, advisory boards, boards of directors. It really, we're wanting to bring those minority populations and those minority groups to the table and hear their voices in terms of planning, assessing, oversight within our organizations, so that we are faithfully representing the communities and individuals we serve and the diversity of those communities. Prohibits discriminatory activity in a facility built in whole or in part with federal funds. So, for example, even if your organization doesn't actually receive federal funding, but maybe you are co-located in a family justice center and the family justice center was built in whole or in part with federal funds, then your organization is beholden to Title VI. It requires that information and services be in languages other than English, when provided to a significant number of beneficiaries who are limited English speaking ability. So what that basically means is if you have a significant population of Spanish speakers or Arabic speakers, German speakers, whatever it may be, if you have a significant LEP or immigrant population within your community, within the community that you serve, you should be and must be providing language services, translation, interpretation in those languages that are represented within your community. And again, that goes back to access and one of the main purposes of Title VI being making sure that organizations that receive federal funding are accessible to minority individuals, to immigrant individuals, regardless of race, ethnicity, or background. And at the end of the day, the main purpose is to make sure that everyone has access to federally funded activities, things like WIC, things like court, legal services, legal aid, public transportation, victim services, medical and mental health services that are subsidized by the government, public parks and recreation, all of those things that are paid for with government funding should be accessible to all individuals, and that's the purpose of the law. So when we're talking about discriminatory activities, I want some examples of activities that are prohibited. For one thing, just basic, that you can't discriminate either directly or through contractual means, which means you can't deny program services, you can't deny benefits, that you have to provide the same service in the same manner to all clients, regardless of their race, regardless of their national origin, regardless of the language they speak. And you can't segregate services based on race, color, or national origin. So you have to provide equal services. You have to provide the same services in the same manner. So for instance, if you have a client who speaks Spanish, you can't deny them or provide them lesser services than a client who speaks English just because there may be a language barrier there. And so when we're talking about disparate impact, we are also wanting to make sure that programs that disproportionately impact minority or low-income populations in negative ways are not happening, because that's another Title VI violation. So just like we want to make sure that we're not giving more benefits to non-minority individuals or more benefits to higher income areas, we also want to make sure that we are not negatively impacting lower income or minority areas. So the example for this is, if a local government was locating most of their landfills in a highly populated African American community, this is a disparate negative impact. And this is a Title VI violation. And so we've already talked a little bit about this as we've moved forward, but there is a large tie between Title VI and working with LEP or limited English proficient individuals. And so basically what that says is that those receiving federal funding or federal assistance must make reasonable steps to ensure that LEP persons have meaningful access to the program, services, and information they provide. The covered agency is required to take steps to ensure that meaningful access that includes using interpreters for communicating with the clients, posting their signage in other languages. The example given here is Spanish, but again, it's whatever language and whatever populations are present within your community, within the community that you serve. So that could be Spanish, that could be Arabic, that could be German, whatever populations that you have, and it could be a combination of multiple different languages, depending on the makeup of your particular community. You can use things like language line, which is interpretation services via the phone, in-person interpreters. You should be translating vital documents, things like intake paperwork, things like the grievance procedure, things like your confidentiality agreements, all of those things that are vital to your clients and to your services should be translated into the appropriate languages so that your clients are aware of and fully informed of what they're signing so that they can see and read the documents so that it is, again, meaningfully accessible to them. Posting signs and brochures and different documents like that in translated languages that correspond with the communities that you serve. So all of this comes together to make sure you're ensuring meaningful access, to make sure that the clients you serve can fully and completely communicate and understand your staff, your advocates, your organization. So here are some proactive best practice steps to make sure that your organization is in compliance. Number 1, distribute your Title VI information. Make sure that people are aware of it. Not only your employees, but the general public and your clients have information on your Title VI policy and procedure, especially your complaint or grievance procedure. Brochures, post it on your website, make posters or flyers. Make sure that your Title VI information is well distributed, it's translated into the appropriate languages, and that it's visible. Have a complaint process. This is sometimes called a grievance procedure. The best practice is to have a person in your office assigned to be the Title VI coordinator. And ideally, this person should be in a management level. The Title VI coordinator is going to be your point person for things like ensuring training, for making sure that all complaints or grievances are thoroughly investigated, for making sure that your organization is in compliance. You want that central person, that point person that people can go to make sure that your organization is doing what it needs to be doing. An example of a complaint process. Complaints must be written and signed and filed within 180 calendar days. Should include the name, address, phone number, and other identifying information, the name of the person who discriminated against you, what the incident was, and that the complaint will be addressed in 60 days. So there are some key points of this example. Number 1, complaint should be written. It should be a written and signed record. Your grievance procedure or your complaint process should be written into policy and procedure so that people can easily find it, and there should be a form that they can fill out if they do have a complaint or grievance. Should include this identifying information. Although note that the person being discriminated against the victim of discrimination doesn't necessarily have to be the person who is filing the complaint. Someone else can file on their behalf, or someone who witnessed the incident but wasn't directly the victim can file as well. Your complaint process should have clear time limits as to when it should be filed and when it will be addressed. The time limit should be reasonable. And again, you need this laid out in writing. You need a policy and procedure that is in your personnel manual, that is in with your client information or whatever paperwork you give to clients, that is well documented and easy to understand. Conduct a Title VI self-evaluation. And there are lots of pieces to this, but we're wanting to make sure your employees have been trained, that there's a Title VI coordinator, and that you've properly evaluated any complaints or grievances. So the self-evaluation should include things like, again, making sure that someone in your agency has been appointed to serve as Title VI coordinator, that they know that they're the coordinator, that they know what that position or what that responsibility entails, and that they have been well trained on Title VI, on what Title VI is, and what complaints look like, and how they are supposed to deal with those complaints. We're making sure that minority individuals are represented on your advisory board. And the suggestion is that if your community, if a minority population makes up at least 5% of the population of your community, then you seek out those people to be on your board, to represent the whole diversity of your community. Now, 5% is just a suggestion. It's just a way to put a number to this quote-unquote significant amount. But frankly, you should be reaching out and attempting to always make sure that your advisory boards, your board of directors, your staff and personnel and volunteers are a diverse group, to make sure that you have a diverse set of voices represented in order to be able to best serve the clients that you see. You want to make sure that a written policy and procedure exists for hearing and reviewing Title VI complaints. You want to make sure that these complaints or grievances, the records of them, are maintained, regardless of whether they were investigated and it was determined nothing happened, or they were investigated and it was determined if it was an issue. You want to maintain all records. And you want to maintain not only the grievance itself, but the record of the follow-up and the review and, you know, the decision made in that process. And you want to make sure that all of your staff are specifically informed about their rights under Title VI and that they have regular ongoing training. Staff should have yearly training. They should be periodically appraised of their Title VI rights, and they should have, again, annual training about Title VI. That's why the coalition does this training, usually every year in June, to make sure you all have the opportunity to receive it. There is also training available online through the state, through, I believe, OCJP, and all kinds of videos about Title VI that you can find to help train your staff. But you should be thoughtful about making sure that not just new employees, but all employees are regularly trained about this issue. All contracts between your agency and other parties, whether you're subcontracting through a grant, whether you are contracting with a trainer or an other service provider should include a Title VI statement of compliance. Title VI information, including posters or brochures or whatever, should be prominently displayed, openly displayed within your organization. And wherever possible, these posters and brochures and notices should identify your organization's Title VI coordinator. That way, individuals who are interacting with your agency know who their point person is, know who they should and can contact if they do have a question or an issue. So that brings us to the fact that you should have a Title VI statement, just in general. This statement is something that you can put in contracts, but it's also something that you can put, again, on posters, on brochures, on your website. So having this statement created and ready to go is really important. And this statement can be very simple. This is the coalition statement. It shall be against the policy of the Tennessee Coalition to discriminate against an individual based upon that person's race, color, or national origin. This policy applies to applicants for employment and current employees, as well as persons receiving services from the coalition. It can be very simple. And your statement can also include other protected classes if you want to go ahead and include things like gender identity, sexual identity, age, disability in this statement to make it more encompassing. As long as you do include race, color, and national origin, you can make one simple encompassing statement that covers all of those different protected classes and the different discrimination clauses in all of the laws and grants and things that your organization is beholden to. Make sure, again, that your employees receive training. So, very briefly, I've said all of this about the importance of Title VI, the reason that we use it, and how to make sure your organization is covered. What happens when your organization is found not in compliance? The worst case scenario is that you're going to get a withholding of payments. You're not going to get a payout from your invoices through the federal grants that you have. And you may have a complete cancellation or termination of your federal grant contract. Now, typically, before you have a termination of contract, the Title VI office will try to provide technical assistance to help your organization become in compliance. But the reality is, if you're receiving multiple grievances and complaints and your organization is out of compliance and you're not getting regular training, you're not taking the technical assistance that the office is providing, then your contract will be terminated. And I know that for most of our organizations, federal funding is a very big deal because there's not a lot of funding for victim services, and the money that we have is incredibly important. So, not only is it vitally important to follow Title VI just to make sure that you are appropriately and completely and equitably serving clients, for your continued funding, it's important that you follow these rules. So here are a ton of resources. These resources are excellent for additional reading on Title VI compliance, on civil rights and responsibilities. This is a really good primer to give to your Title VI coordinator within your organization. If you have any questions on Title VI, on what we've talked about in this training today, or you would like a copy of the slides, please don't hesitate to email me. I am available to you at any time. Email is typically the best way to get a hold of me. Thank you for being on the line today. I really appreciate you.